Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book from Edward Elgar. It's part of the Elgar series. It's actually available also online on the Elgar online part of what they offer. So there are two different websites to look at should we wish to follow this up. The book is called Academic Learning in Law, this book here. It's got a subtitle, Theoretical Positions, Teaching Experiments and Learning Experiences, and it's been edited by two people, Bart van Klink and Ubaldus de Vries. Now, I'm mentioning right at the beginning that I really like this book for a number of reasons. Apart from being a practicing barrister, I'm also a fully qualified teacher to go through all of the very interesting PGCE training, including online training and all the actual teaching experience itself, the actual teaching hours. Now, I've found this very interesting for a number of reasons, because I've taught law and I have my own views about how you actually teach it, as we all do. And I think you would think, oh no, not again, not another one of these books about academic teaching of the law by people who've got no idea about what it's about. Now, with great respect, I understand that point of view because I've come across it. But most people like me, I have to bring a practical element to whatever aspect of law I'm teaching, because that's the only way to communicate it, because law affects everybody with everything that we do. Now, I say that because, again, we can have all the very high style philosophical discussions, which I find fascinating in terms of jurisprudence, but the bottom line on it is, how are we actually teaching people law, and what is academic learning in law itself? Well, let me give you the title of our review. We've said a stimulating book for all law tutors to read as they prepare their learning programs, because that's really partly what it's about. This is the book. It's a hardback and some interesting little pictures, presumably rather modern university there. Then you've got the spine. Then you've got quite a lot of detail on the back, which explains a few quotes as well, which explains what the book is actually about and what legal education is about itself. The book itself, inside, you've got page numbering for the index, so you find things relatively quickly. And then after the index itself, which is there, you've then got the actual text, and you've got, right at the end, quite a large number of comments from various people about specific conclusions, right, of course, at the end of the book. Now, at the beginning of the book, you've got the front page. Then you've got the list of contributors, figures, and all the other information, plus the main contents section, which is split into 3 parts and 16 chapters in total. There's some figure work which is included, some tables, and then you've got the list of contributors, a large number of them involved, you can see, very large number of people, and then we go into the preface itself, which sets out where this book came from. I'm going to talk about that in a moment. The two authors have written the actual preface in June 2016, and I'm recording this in the summer of 2016. Then you go to the main book itself. There are footnotes, of course, right at the bottom, and there are some subheadings and numbering. There's no paragraph numbering as such, but you do have some useful conclusions right at the back of the book. Now, I found this interesting. I'm sure quite a large number of people who've done what I've done, which is to both practice, which I do, and also teach the subject, will find this book of some interest. They may not agree with some of the comments, or quite a lot of the comments, which is the way it is in education, but I'm sure it will be of some help. So what do we say about the book? Well, we say this. Edward Elgar published a most stimulating book with this collection of essays brought together by Bart van Klink and Ubaldus de Vries, called Academic Learning in Law, which just has to be the rather more prosaic, just has to include the rather more prosaic subtitle, Theoretical Positions, Teaching Experiments and Learning Experiences. And we're definitely for the latter, the learning experiences. Now, we are using words again which, alas, crop up frequently in the education world, so just put aside any concerns you have, and remember, we have a slightly different vocabulary when it comes to educationalists. And as a learning experience, Bart and Ubaldus have worked some magic here, we think, to give us suggestions on a more human approach to the teaching of law, which we've always found does work with the learners. I certainly have, because trying to explain the philosophical theory of something is pretty boring. But when you're dealing with Mr. X and Mr. Y having a problem, or whatever it might be, civil or criminal, it starts getting interesting because the personal side comes out very quickly. And that, of course, is what draws so many people to the law. So, the teaching of legal education and the law is not an undertaking to be considered lightly, because it can be technical, but it does rely on those words relevance, coherence and effectiveness, because that is what the client would expect, and the subject matter is, of course, about the human condition. And that was drummed into me at bar school as much as anywhere else. Certainly when I did my undergraduate degree, relevance is a very important factor, and it always crops up in a court when you're cross-examining, or particular things when the judge is trying to hurry you along because he's saying, is it relevant? Is this, do we need to go in this direction? And you see that on the television in the bowdlerized versions of lots of cases where they have to cram everything into a few minutes when it takes a lot longer. So you can see the problems. Now, in this book there are 15 contributors, including the 2 editors, and we are told that the original idea of a book on academic learning in legal education resulted from a discussion meeting in Utrecht in 2012. The view then and now was that at a conference, research topics are discussed where the other main task of legal academic activity, that is teaching, can so often be neglected as this sort of research topic, with research coming first and teaching coming second. Now, we've had this argument about research and teaching beforehand. It's continuing because there are still a lot of views around that there is insufficient research now taking place because of cuts and various other things. But I don't necessarily agree with that. I think there's always going to be that substantial element of research, but I have to say I come down firmly on the side of teaching first. The research is adjunct to that, it's ancillary to that. It's very important for individuals, but the basis is imparting the knowledge and the way we do things to the learner. And that seems to me to be the sensible outlook. However, other people may have different views for different reasons. Special mention, I think, should be made here of Tim Bleeker's contribution as the assistant editor of this book, whose epilogue, which is at chapter 15, presents an excellent overview, plus reflections and a student's perspective, which readers will find most helpful. And the editors describe their work in the following way. They say, this timely book calls for a critical re-evaluation of university legal education with the particular aim of strengthening its academic nature. They go on to say it emphasises lecturers' responsibility to challenge the assumptions students have about law and the importance of putting law in a theoretical and social context that allows for critical reflection and sceptical detachment. Interesting observation there. In addition, they go on to say, the book reports upon teaching experience and innovations, offering tools for teachers to strengthen the academic nature of legal education. And I think that's the benefit of this if you're preparing your learning programme and what your learning outcomes are going to be. So I can see that that will be of substantial benefit, especially if you're being observed when you're doing it. So you can say, well, this is how we've done it. So you fit in nicely with, in fact, what the observer is looking for. I think it's also well described with the view that the nature and purpose of legal education has become a topic of intense debate in recent years. That's certainly the case. Quite right too. So this timely book calls for a critical re-evaluation of university legal education with a particular aim of strengthening its academic nature, something most of us in the academic community would agree with, we hope. Now, I say that I agree with that, but there has to be the hands-on practical aspect as well, because when you are teaching law, for instance, in quite a lot of the substantive subject areas, substantive law areas, you will have not just the essay questions, but you will have the problem questions. The problem questions are very much, whilst there's the academic element to it, which is the intellectual argument you'll put to the judge, the basis of quite a lot of that problem question is actually about the practical approach you're going to adopt to a piece of legislation, case law, or whatever it might be. So I do think you have to have a balance there. That is not to say that you should always have the intellectual approach adopted. So you question and look very carefully at what is being done. Although do remember, when you're in court, you're not questioning that side of it. You are making a submission or an assertion on behalf of your client for the judge or the jury or whoever to take a certain course. Now, let me say that the 15 contributors place special emphasis on a lecturer's responsibility to challenge the assumptions which students may have about law. It is rightly said that the importance of putting law in a theoretical and social context that allows for critical reflection and sceptical detachment in the long-term goal of teaching the subject is obviously very much the thing that one should strive for, and I think they're successful in explaining that in this book. The editors have ensured that the book reports upon teaching experience and innovations with the aim of offering tools for teachers to strengthen the academic nature of legal education itself. Now I think again that is right, and this is another contribution to that debate, and it finishes of course with thought-provoking concrete proposals for change, which at least have been put forward. Whether anything happens to this, like a lot of other things, we want lots of reviews in lots of areas, because we're going to be moving, before we know where we are, towards the middle of this century, and we're going to have to start thinking very clearly what sort of changes we want to see as we have new directions, new technologies, a fourth industrial revolution upon us with technology and so forth. Let me conclude by saying that we feel that learners and scholars who are engaged in the debate regarding a re-evaluation of academic legal education will find this book particularly helpful for their work. It will also be of interest to practitioners and advisors, such as educational experts and administrators looking to understand the modern role of law schools in creating responsible citizens. And the publication date is 2016. Now, this is the book, here it is, and this is the actual spine, and then the back. I have actually quoted a bit of what is on the back in the review because I think it's important to know exactly where the editors are coming from. We just open it up. I just want to show the name of the contributors again for you, because a lot of people have put a substantial amount of work into this. There they are, all of them mentioned, the 15. And then you get the preface itself, again, which I've mentioned in passing in the review. Then if we open the book up, academic education and socialisation, the problem areas. You see, you are looking, this is a high standard of debate, certainly, and so it won't appeal to everybody, this book, but I certainly found it very interesting. And I mentioned the epilogue, which I think is well worth reading, mainly because it's looking at the overview of the book, the student's perspective, and basically we then get the conclusions of where we're going. So all in all, I'd like to thank Bart Anderbuldus and also all the other people very much indeed for, I thought, a very thought-provoking book. It's not in fact going to be one that a very large number of people will read, but I think if you do teach law and you're a practitioner and this is the sort of thing that you are querying and thinking about, this is certainly something one should look at very carefully for the future. So thank you to all concerned for this excellent book. Bye-bye.